Welcome to Bridgeford Trust Company's Finding Certainty in Uncertain Times, the power of modern U.S. trust law and trust situs selection. It is great to be here. It's great to see so many friends joined us today. We have friends literally from all over the world, and I'm doing something a little different with this webinar. As you can see my face. I don't know if that's going to add anything to this webinar, but at least that's an enhancement that we're trying to do this time around. And we're excited about it. We're excited about the topic. I'm excited for the opportunity to reach out to our friends in this way. There's no question the last 6 to 7 months have been completely and totally uncertain and unanticipated. And I think that certainly our thoughts and prayers have been with all of you, our old friends and new friends, and hope that you're all doing well as things continue to be difficult at times, although I think there's certainly some light here at the end of the tunnel. But certainly uncertainty remains, and that's the topic of today. I will say, as we begin, amazed, as difficult as it has been for really all of us around the world. What has struck me is the unbelievable resiliency and adaptability of really the human spirit. I think, certainly in my generation, we've never expressed or gone through something like this, rather. And watching the creativity and the adaptability and really the power of the human spirit has been incredible. It's been amazing to watch our Bridgeford team adapt and overcome fear and uncertainty and perform outstanding throughout the many months of confusion and uncertainty. I'm very proud of Bridgeford's team, very proud of what Bridgeford has been able to do through this process, and proud to have been able to work with so many of you over the last 3 or 4 months. So as we begin, the goal today is to talk a lot about while there's so much uncertainty in the world right now, there's no question, and there's so much that we're sort of worried about. There's also, though, still a great deal of certainty that we can bring to the lives of our clients, the lives of the people that we serve, and really to the lives of everybody around us in terms of the power and sophistication of modern trust law. And that hasn't changed. This is a quote that has always resonated with me by one of my favorite songwriters, and I think it is more true now than when I had first heard it back in the 90s. Don't worry, it's all going to be all right. Uncertainty can be a guiding light. And for me, and I think for so many of you that have tuned in and I've talked to over the last several months, the uncertainty has become a guiding light, a motivator to move forward, to find new solutions, to solve problems. And I think that quote, as I said, coming through the COVID crisis and approaching a very uncertain political climate through the presidential election, the uncertainty is creating a guiding light, and I think in some ways showing us a way, particularly in the trust space, and reminding us that there is still certainty and there are still things we can do for our clients to remove and address some of the concerns and the uncertainty. Clearly, the presidential election is on everybody's mind, and yesterday's debate certainly didn't create any certainty there. That's for sure. It may have been a bit of an embarrassment to the world, but the reality is, as we move forward and deal with that uncertainty and the uncertainty through the COVID crisis, we ask ourselves these questions: Trump, Biden, Republican or Democratic control, doesn't matter. That's really, to me, the pivotal question that I wrestle with, because I'm not sure that it does matter, quite frankly. I think change is coming no matter what. We know for sure that there's going to be an impact, regardless of who the president is or regardless of who's taking control of Congress. Because change has to happen. There are fiscal budgets that we'll talk about later in the webinar that are under extreme pressure right now, and whether if whomever's in power is going to have to address at the state and federal level. So I think the question isn't do we respond if Trump isn't reelected or if Biden becomes the president. I think the question is, what do we do today with the tools that are available to us to be prepared no matter what? Because again, there's no question in my mind and in our minds that change is coming. So our first polling question, and this is for our CPA friends to make sure that everybody's paying attention and able to get their credit, is: which state is considered a top-tier trust jurisdiction? New Jersey, South Carolina, Florida, or South Dakota? So we'll give you some time to answer that as I talk a little bit about finding certainty in trust situs selection. Before COVID and before the uncertainty and turmoil of our political world right now in the United States, we knew and always knew that there are top tier trust jurisdictions that attracted us. It's certainly no secret. Bridgeford Trust Company is a South Dakota trust company deliberately, and we're there and chose that jurisdiction for many powerful reasons, which we're going to talk about today. And generally speaking, these are the jurisdictions that have been looked at well. And we are going to examine Wyoming. I add Wyoming with a question mark because it's very interesting to me how Wyoming has positioned itself as a top-tier trust jurisdiction, although lacking in many respects with regard to modern trust law. And we're going to examine that a little bit later. So I believe we have some results. We do. We have results. And shockingly, 98% of you said South Dakota. So great. And I think I'm going to talk a lot about South Dakota then for the next 55 minutes or so. The choice of a state in which to establish a trust is as critical as a decision to create one. So many of our friends on the line here or on the webinar from around the world have heard me say this before, and I'm going to continue to say it because it's always been, for me, a guiding principle of why we started Bridgeford and why I and our team is just so passionate about the assets, rather the jurisdiction selection. And as we continue the theme of finding certainty in uncertain times, this is probably one of the most important decisions we can make to get some certainty in terms of how we can anticipate how we want to plan for what's going to happen as we go through some of the turmoil. The Dynasty Trust and where we're focusing now on purpose is really, regardless of whether exemptions change, regardless of whether the gift tax exemptions are going to change, or if Biden is elected and the exemptions go down to $100 a year, or whatever calamity we're worried about with the change of power. The reality, though, is that there are still tools available, regardless of what happens in November or a year from November, when changes are happening. And again, I think change is happening anyway. So why not bring the certainty over generations now by using the Dynasty Trust? South Dakota was the first in the nation to repeal the rule against perpetuities in 1983, in my mind, beginning what we call modern trust law. And so many of you know this concept, and it's probably one of the most popular concepts used around the world right now, particularly out of South Dakota, who, as we'll talk about later, has consistently been named the strongest trust jurisdiction, dynasty trust jurisdiction in the nation. So this is no stranger to Bridgeford for sure. But the definition simply is a trust that can live forever. So therefore, it's never subjecting the assets to federal state taxation. And it's powerful. And it's something that is used virtually in every single one of the trusts that we work with our domestic and international families. And it's become, a part of the conversation now as modern trust law has evolved. And I think, again, this is the foundation of it. They're not, the dynasty trust states, as I mentioned, are not created equally. As we get towards the end of the webinar, and I encourage you to stick with us till then, we're going to show you in particular detail the nuances that differentiate states from one another and the aspects of those nuances that is unequivocally, in the view of certainly Bridgeford, but people around the world, that renders really South Dakota the strongest of the top tier trust jurisdictions. So setting the stage, there's another aspect of certainty here that when we're talking about taxation, and this is actually another area that I'm particularly passionate about, because it really involves the Supreme Court and its ability in the last, within the last 2 years to give us guidance and real clarity. State taxation, we all know, of course, in setting the stage that up until recently, it was presumed appropriate for states to tax undistributed income in a trust. So the example is a trust is in California and it's a $50 million trust and it generates $500,000, let's say, in undistributed income that remains in the trust in an investment account, let's say at Morgan Stanley. Up until modern trust law came along, that undistributed income was taxed at a very high rate in California, not as high in New Jersey and Pennsylvania, but nevertheless a tax that has been determined by the Supreme Court to be unconstitutional. And so practitioners, before these cases became available to us, believe that a state like California cannot tax undistributed income inside of a trust that's properly sitused or properly maintained and handled in a South Dakota jurisdiction that does not have a state income tax. And so the idea there is pretty profound. As I mentioned, the Supreme Court looked at that, and there's also a handful of appellate court cases across the country that hold very similarly. So there's great guidance here with respect to the case. The case, of course, is called the Kasner case. There's also a case called the Fielding case that was accepted for cert, cert was denied, meaning that the lower court decision, which happened to be the Minnesota Supreme Court, came to similar conclusions. It's a constitutionality issue, and really what we're talking about is nuances that are very, very important with respect to state income tax. And I like this so much because, again, it gives us certainty in a world right now where everybody's wondering what's going to happen next and how is business going to restart and what's going to happen in Washington. Well, here's a tool that we know works, and our clients are availing themselves of this, and I love the certainty that it brings. The Minnesota Supreme Court, as I said, ruled in Fielding along similar constitutional lines, and these cases again give us great guidance and forethought. And there's a lot more information certainly on our website if you'd like to see that in more detail in terms of what exactly those cases held. Continuing the theme of finding certainty here with respect to the tax world, many of you that have joined us today know just how excited we have been about the idea of the incomplete non-grantor trust. That is another area that allows for tremendous tax savings, particularly with respect to low cost basis assets that are transferred into the trust. That is a whole nother aspect of tax planning and a whole nother realm that, when combined with the other aspects of a dynasty trust and the ability to avoid taxation on undistributed income, starts to add up to some pretty powerful dollars. And again, back to the certainty theme, there's strong PLR support, private letter of ruling support out of the IRS. They've looked at this time and time again, and we're aware of no situation where any of these have been pierced or shot down by any tax board across the country, particularly California, which we all know is one of the most aggressive in the world, perhaps, but particularly the United States. And they have not figured out a way to take this concept out or off the table. The example is very, very easy to look at. I mean, the savings potentially here with these concepts that we've talked about adds up to something pretty powerful. And assuming if there's a $20 million gain, the numbers speak for themselves. If you're in a 6% income tax rate, you've saved $1.2 million in taxation by virtue of having the asset inside the trust when the sale happens or when there's a transfer. And then, of course, you assume that there's investment portfolio in there. And as I talked about, with the inability for a state to tax undistributed income, if income is not distributed, there's another savings, and 4% is pretty conservative, because when you're thinking about California, which is over 13%, then the number is even more real. So we're not just talking about esoteric concepts here. We're talking about absolute planning tools that have tremendous support and bring tremendous certainty, even in the midst of tremendous uncertainty right now. Another area of certainty that spouses can enjoy with respect to taxation is the South Dakota Community Property Trust. South Dakota is one of 3 states that has the Community Property Trust. I think Tennessee has it, but has some restrictions on the ability to use it. So really, Alaska is probably the only other choice. South Dakota's is much newer, and we would argue much stronger and more favorable to spouses. And essentially what we're able to do in conjunction with all the other tax plays I've already mentioned, we have the ability to have assets inside of a properly structured South Dakota trust take on attributes of community property, allowing for a 100% step up in basis as to the date of death of the first spouse, which is, again, pretty compelling, and it's a matter of the numbers. And when you combine these strategies together, as I keep saying, these are real moves that you can make that have great support among PLRs and now case law. So really, finding tax certainty with trust planning is still available. You know, as I said earlier, regardless of who takes power or what changes may or may not be coming, we still know that we can avoid estate tax forever by using a dynasty trust. We know that we can use an incomplete non-grantor trust in lots of circumstances to avoid tremendous capital gains, state capital gains. Avoid taxation on undistributed income, as we talked about, reduce state insurance premium taxation, which is a whole nother aspect of huge tax savings using South Dakota law specifically, and then maintaining or obtaining rather the 100% step up in basis for marital property. And all this happens by simply selecting the proper trust jurisdiction. That's where the certainty lies. That's where we can still avail ourselves of powerful tax planning tools, regardless of what happens tomorrow or into the next day or through the presidential election. But an issue that has become particularly interesting to me and my good friend, an excellent lawyer in South Dakota, Terry Prendergast, who I believe may be on this, and if you are, Terry, hello, pointed out to me and our team in South Dakota last year during a retreat just how powerful this idea of fiscal soundness is and how incredible South Dakota is in that regard. And so this quote, state governments are facing a fiscal crisis boom of collapsing revenues, increased demand for safety net programs like Medicare, and the direct cost of lending. States are under tremendous financial pressure right now. So when Terry pointed out all the attributes to us last year before COVID, we became passionate about the conversation because it's another incredible differentiator, as you will soon see, of South Dakota. But now going in the midst of COVID and navigating through it and coming out of it, the state and the power of the state to not ever have to impose a state income tax is extraordinarily important. I mean, why would we go through the trouble and the expense to come to South Dakota when through a crisis that we're enduring right now, they decide they have to impose a state income tax on a state income tax period. And so when you look at the other trust jurisdictions like Delaware and Nevada and Alaska and Wyoming, they just don't compare well. They're not doing well through the crisis. I feel for the state. I know that there in many cases it's in crisis, and we certainly aren't happy to see it. But it's a reality that we need to consider when we're planning. And I think that this issue is really important. And here are the factors. You know, South Dakota did not shut down to the degree that other states did. So, you know, jobs were maintained, tax revenue was maintained. There was no particular, well, there was some strain, but not the kind of strain on the safety net programs that you see in other jurisdictions. And so that probably is one of the most important details to keep in mind. Also, it's very difficult in South Dakota if they even wanted to impose an inheritance tax and a state tax, because it's first of all, it's unconstitutional. There's a constitutional prohibition against it, and second of all, in order to change that, the state is going to have to come up with 2/3 vote in their legislature, which is not going to be easy. So even the structure itself in South Dakota prohibits or makes it very difficult. South Dakota has a balanced budget, has since statehood. Not a lot of states can say that. I'm not sure any other state can say that at this point. It's still a balanced budget, in fact, coming through COVID. Tax revenue volatility is another very important attribute. A little myopic, but once you understand what they're measuring, it's compelling. South Dakota is number one in this measure. And what the measure is the idea of when and how states have had to change and add taxes or when they take taxes away and the volatility therein. And this was looked at over a 20-year period of time, and it clear, without question, South Dakota had the most stability in that respect, meaning there was no reason for the state to put an income tax on trusts, for example, or change their tax structure, because they're remarkably well run. It has been remarkably well run for 100 years in that state. They have always been good stewards of their resources and of their money, quite frankly, where other states just can't say that because of a myriad of impactful situations they have. Retirement, South Dakota is one of the only states that has their pension 100% funded. The budget surplus entering into the crisis had them in the top 10% or top 10 rather in the country, which means that They could last for a very, very long time on rainy day funds. Again, not a lot of states can say that. Bank deposits. South Dakota, as of the writing of this, or they were number 2 in the country for bank deposits, in excess of $3.16 trillion. That's ahead of New York, which to me was amazing when Terry pointed that out to me. Ohio is only slightly ahead, but that is an amazing statistic given really the population in South Dakota. For years, people know and have known South Dakota is safe. Long before 1983, when South Dakota really kind of changed the world in the trust planning space by being the first to abolish rule against perpetuities, it was always known as very strong. Its fiscal condition was always celebrated over the years as having tremendous budget solvency and long-run solvency. The AAA bond rating is something else. A little known fact, but highly celebrated among South Dakota, in South Dakota and beyond, certainly by companies like Bridgeford, is they were granted a AAA bond rating again during the COVID crisis. Which again, I can't say for certain, but I don't know of another state that had that happen during, again, potentially one of the most historically straining economic conditions ever facing the nation because of COVID. So all of these factors are so important to consider. And I'll talk a bit more about them as you're answering this question. Our second polling question, which is one to see if you were paying attention earlier to the case law that I had mentioned. And I know particularly for the CPAs being so detailed, I'm sure you were, but what is the name of the most important tax case coming out of the Supreme Court in the last 50 years? Was it Roe v. Wade, Kastner versus North Carolina Division of Revenue, Plessy versus Ferguson, or Brown versus the Board of Education? So as you're cogitating and trying to remember, or maybe you're going back and looking at the slides, because I understand they were sent in advance. The idea of fiscal soundness, again, is so compelling right now and has to be considered in conjunction with all the other data points that we use to compare trust jurisdiction, which again, we're going to get to towards the end. I am extraordinarily proud to have come to South Dakota with Bridgeford Trust Company, to have taken the advantage of the strength of the state. It's also considered one of the best states in the country, if not the best state in the country to do business. And I can tell you as a business owner in South Dakota, I would concur. It is excellent to work with, as is the regulation and the regulators, which we'll talk about. So I think the results are in, and 86% of you got it. Excellent. Congratulations. You're doing great so far. There's only one more. So, and I think we have it at the end. So you have to stay to the end here, the last question. And it's, I think, on purpose. Okay, so I guess we can move on to the next topic. So this is another quote that I love, that I came across while we were writing Bridgeford's Trust Charter and submitting our application. And legal experts contend that there have been more change in trust law in the last 20 years than have taken place in the prior 2 centuries. And these changes promise to affect every aspect of how trusts are administered for years to come. That was Trust in the States Magazine 2012. And I would argue it's never been more true today. And of course, I'm referring to what I am and our team at Bridgeford are extremely passionate about is modern trust law and the real revolutionary impact they have had. And this is where certainty and control exists. It existed before COVID. It existed before political turmoil. It existed before all the divisiveness in this nation. And they're going to continue to exist, and they're going to continue to provide certainty for families across generations. And we're excited to talk through some of the concepts. Asset protection trusts, they've been talked about a lot. There's no question of their strength. South Dakota, and as we'll see later, is unequivocally been acknowledged as one of the strongest, if not the strongest state in the country relative to a self-settled asset protection trust. It provides, in addition to asset protection, tremendous control and access to discretionary beneficial interest, and they work. And it's not an opinion of David Warren. It's the opinion of people from around the country and around the world. There has been some debate that other states won't honor the South Dakota's asset protection statute, and sometimes you get involved with these myopic how many angels could dance on the head of a pin discussion in a law review article. But at the end of the day, or at least today, there is no case that has pierced an asset protection trust in any jurisdiction because of a problem with the asset protection trust legislation, or any sort of rejection of the concept of asset protection state by state. Where they have been peers is because there was fraud involved and assets were moved inappropriately or already with the knowledge that a lawsuit was coming. And so we are of the belief that this is an extraordinarily powerful planning tool, and it's been confirmed really by the whole international community. I mean, whether we are happy about it or not, the United States has become a real haven for privacy and asset protection. Strategies like Nevis and Cook's Island, they're falling out of favor for a whole myriad of reasons, not to mention mandatory disclosure under CRS. And people are coming to the United States, and I can tell you anecdotally that we have this conversation a couple times a week with families that come to us through the website or through advisors, and that's what they're looking for: asset protection and privacy. And this is exactly what South Dakota brings, what Bridgeford provides, and its security and certainty in perhaps one of the most uncertain times in the history of the United States and maybe potentially the world. Only a handful of states actually have statutes. There's a handful of states, even smaller handful, that have been considered top tier. I will note, though, and we'll talk more about this, Delaware has been, for 2 years in a row, has been admonished by Trust in the States magazine as if they don't catch up with the modern trust laws in Nevada and South Dakota particularly, they might not be considered top tier. Their asset protection statute, regardless of what you may hear from lawyers and trust companies in Delaware, the reality is it certainly doesn't have the flexibility, and I would argue the quick protection that you can get in a South Dakota or Nevada for that matter. But what's really exciting to mention, however, is a couple things. One, a comparative aspect of why did I say a moment ago that Delaware pales in comparison to South Dakota? Well, not just because I own a South Dakota trust company, because objectively speaking, the look-back period or fraudulent conveyance is twice as long in Delaware than it is in South Dakota. And for that reason alone, again, we believe that South Dakota's approach pales in comparison. Also, what Delaware doesn't have, and I don't think any other state in the country right now with an asset protection statute, is they don't have a case called Cleopatra. In the Cleopatra case is a case that was decided by the South Dakota Supreme Court and was highly celebrated because essentially what the Supreme Court in South Dakota said was they weren't going to honor a creditor claim from the state of California coming through a divorce settlement. And in that case got the attention of a tremendous amount of people. It was not a self-settled asset protection trust, but that's kind of not the point. The point is the Supreme Court of South Dakota made it very clear that it will protect the integrity of its trust laws, and it will not allow another state to violate fundamental notions of constitutionality to pierce a trust that's properly administered in South Dakota. The Cleopatra case is on our website. You can certainly take a look at it. And again, it's a very big differentiator and one that we're very excited about at Bridgeford and has picked up a lot of attention. The emergence of an upstart non-depository public trust, public directed trust company is a disruptive force to be reckoned with. Again, 2002, out of Trust in the States magazine. I am referencing, in my opinion, one of the most revolutionary aspects of South Dakota law, of modern trust law, and that's, of course, something called the directed trust. And as we continue the search and the desire to obtain as much certainty and control as we can through all these uncertain times, the directed trust is a perfect tool. You know, in conjunction with all the other advantages, as I've already talked about relative to the taxation of trust, we have the ability under South Dakota law to create a structure that delivers tremendous control and direction to settlers of trusts, their advisors, and beneficiaries over generations. And essentially what it does is bifurcates fiduciary roles such that allows and opens the door for companies like Bridgeford to work with investment managers all over the world in an agnostic way. We don't manage money. We can partner with asset managers, and we have partnered with many of them around the world and around the country to provide this unbelievable ability for any family, particularly large families, to keep control over important decisions, like who's going to manage their money and how is it going to be managed. You know, it's inconceivable to me that we have a system in the United States with a big bank trust department that manages money and is your trust company, and they tell you you have no choice, and they charge you too much for it. That system is amazing to me that it has existed for so long. The directed trust grew out of that disgruntlement, in my view, and it's really an industry correction to what has traditionally been, in my view, and I think the view of others around the country and around the world, a problem with U.S. trust law. And so, as you can probably tell by my exuberance, I'm very excited about the concept, and it's something that we use routinely and talk about multiple times a day with people who find Bridgeford in South Dakota. Another aspect of control and certainty is the trust protector. We love this concept too. It's been referred to as a super trustee. It has, in fact, can have more power than the trust company itself. Has the ability to remove the trust company, change jurisdiction, change investment managers, make distributions. Extraordinarily powerful. And it's a safeguard for families who, in the days of the old days of irrevocable trusts, when they were rigid and expensive and seemingly losing all control, or taking all control, I should say, away from the family, this concept, the trust protector working in conjunction with the directed trust structure, gives so much more control back to families. And by simply putting somebody in that trust protector role that you trust, no pun intended, to do what you ask them to do. So if you, a settler of $100 million trust, are not happy with Bridgeford Trust Company, well, you just tell your trust protector to replace us. Well, as much as, and that keeps somebody like a Bridgeford doing its job correctly. I mean, in the old days, like 20 years ago, or before this concept existed, if somebody wasn't happy with Bank of New York Mellon or PNC, in most cases, they had to go to court to remove them. So this, again, delivers so much more control back to the settlers of trust and their families, and I think is an amazing evolution of trust law in the United States, and one that we wholeheartedly embrace and recommend to the families that we work with. South Dakota is in its cutting edge mindset, has created something called a Trust Protector Lite that as it has been referred to. Of course, the Family Advisor. It's very much like a trust protector, except not a fiduciary. No other state in the country has this. It's a major differentiator between South Dakota and Nevada, and I can tell you a big reason why people have been coming to South Dakota. And it has some limited powers. It doesn't have the expanded scope that the trust protector has. And South Dakota very intelligently anticipated that some people don't want that much power, and it didn't want to take on that responsibility. And so they created a non-fiduciary status, which clears the way for people to appoint close members of their family or close people in their network to serve in a role that carries with it less responsibility. And essentially, these are the things that they can do: remove an appointed trustee, appoint a successor trustee, and advise on certain matters. And there's more information, of course, on our website. There's the citation to the statute. Very unique, and again, another testament to South Dakota's progressive thinking and ability to always be a step ahead and to look for ways to serve families. Maintaining certainty. So we talk about, the view that in this uncertain, unsettled world that we're in, there's many different tools around obtaining certainty in taxation and planning. But the question is, how do you maintain it? And that is where decanting comes in. I mentioned earlier this idea of an irrevocable trust has been such a scary concept. When I was in law school and a young lawyer, I didn't like it because it seemed like the family lost all kinds of control. I just explained why that isn't true anymore. But this decanting tool is another ability that we have under modern trust law to essentially address problems in trusts, is basically what that is. The idea of decanting, much like wine. Of course, you're pouring assets of an old, tired trust, we say, into a new trust that is modernized and has been given the ability to take advantage of modern trust laws that I've been talking about. So these are the reasons and why people use decanting. South Dakota unequivocally has the best decanting statute, according to a Nevada attorney. It has consistently been pointed out, and we'll get there towards the end of the presentation. And we use that routinely. And that is, again, another area of certainty. If you don't like the trust or if you don't like the planning and it's not performing the way it's supposed to, then you can change it into something that does perform the way you want to. New York was the first to have one. Several states have statutes. But again, South Dakota has routinely been recognized as the most flexible and the best in the nation. Interesting question was raised by the Massachusetts Supreme Court, in the last couple of years, raising the question, is there a duty to decant? I think trust companies, lawyers, trust protectors, anybody acting in a fiduciary capacity, I would argue, whether a family should be aware of this potential if this potentiality happens, meaning if in fact there is a fiduciary duty to decant, then essentially you get sued for malpractice for not doing it. And that's essentially what the court had mentioned when wondered when it becomes malpractice. I mean, if a trustee, and here's the example, and it's an easy one to measure the malpractice claim. If you know because I've just explained to you, if you take what I say as true, and by simply moving a trust out of California into South Dakota, you can save state income tax on undistributed income. You can have it live forever and avoid a state tax forever. You could avoid capital gains. You can get step up in basis, all the things we talked about just by moving it. If a trustee doesn't do that to protect the assets from unnecessary taxation in South Dakota, or rather, I'm sorry, Florida, then why is that not malpractice? And that's what that Supreme Court in Massachusetts case said. And we were paying attention to that issue. I think the question of asset, or rather situs selection, may become an issue of malpractice down the road if practitioners don't talk about it and document or file that they pointed out that there were better jurisdictions to be in than perhaps the state they live in. And that'd be interesting to see how that plays out. The final polling question. According to Trust and Estates magazine, which top-tier trust jurisdiction has the most powerful privacy laws? Now, I've alluded to it a few times. We're going to talk in much detail in the following slides. But what do you think? Delaware, Nevada, South Dakota, or Alaska? And, as I mentioned before, the idea of privacy and asset protection has driven so many families into the United States. That's a topic of another webinar that you can see on our website in our Insights section. We've talked about it in our blog posts consistently. We talk about it in our podcast. And the idea of the United States becoming the privacy and asset protection haven is probably something that most of us never expected. But it's the reality. And Bridgeford, of course, as so many of you know, has positioned itself as a real thought leader in that space and as a trust company with an appetite and a desire to work with families around the world. So the results are 93%. Wow, that's excellent. Yes, South Dakota is, according to Trust and Estates magazine, year after year, has the most powerful trust privacy laws in the nation. And we're going to talk about why in a few minutes. And here we are. Controlling private information, another aspect of certainty. Nobody likes their information part of the public domain, of course. And I'm not talking about secrecy, and I'm not talking about hiding nefarious activity. I'm talking about really a fundamental right that we should have as people, not only Americans, but as world citizens, to keep your private information private. And that is what South Dakota has done over many years ago. And as I've said today, has the most powerful privacy laws. Again, not secrecy. Made up of really two aspects. There's the quiet trust, which basically says there's no mandatory disclosure of the existence of a trust to a beneficiary. And that direction comes from a trust protector. Powerful because often families that have hundreds of millions of dollars in trusts where their children are beneficiaries, and they would prefer they don't know that when they're in college, because they likely will not go back to college if they realize that they have access to a $100 million trust. So we hear all the time that is a huge driver for families around the world that want to avail themselves of that quiet trust provision. Court seal. Very powerful and in an area a lot of folks don't realize. In most states, if the trust becomes embroiled in litigation of any kind, very vital information about the trust and its assets and the people who are managing the trust become part of the public record. And you can do that by just searching court dockets, especially now with hyperlinks and everything else. I mean, all the information just becomes public. Well, South Dakota years ago noticed that. I didn't like it. Thought it was a violation of privacy, and they created a total seal forever, meaning that when a trust is properly established in South Dakota, there is no ability for any of that information to come out through a court case to hit the public domain. And it's not discretionary. You don't have to ask a judge for it because, you know, we all know judges don't always make the same decisions or even the right decisions. In Delaware, you have to go to a court and ask the judge to seal it. And I don't know what the statistics are, but I would much rather have it be sealed by operation of law than rather relying on a judge. And it's only sealed for 3 years. So, you know, South Dakota is sealed forever, and in most states, it's all open to the public. Very, very important aspect of why families are coming to the United States, and particularly coming to South Dakota. So where we like to go now, and for those of you who have worked with Bridgeford, and of course we appreciate that, you know, we love charts, and we love education, and we love objectivity. We have, in a very objective and educational way, have attempted to be of value and of use to our advisors and families around the country and around the world, giving information that is not salesy, but is objective and true. And in a world of fake news, I think having truth be told is obviously perhaps novel at this point. And what we're seeing here through this chart is an objective comparison of 5 states. Where you see Nevada, South Dakota, Wyoming, which I don't consider top tier. Many people don't, but it's on there, and for reasons I'm going to get to. Alaska and Delaware. What I'd like to do in this slide is sort of break it down and talk about it in the context of particular state comparisons and data points. South Dakota, for at least 7 or 8 years, has been acknowledged as being the top dynasty trust state in the country by a Nevada attorney who I have tremendous respect for. He's very prolific, he's very bright, he's very creative, and he, because he's objective, has come to the conclusion, looking at a lot of data points, that South Dakota is the strongest over Nevada. And I often get asked the question, well, in the South Dakota, Nevada, what's the difference? I like Nevada. Why should I like South Dakota? Here's why. There is no community property trust in Nevada at this point. There's no community property trust, so you can't get that in Nevada. South Dakota has been considered to have the top decanting statute over Nevada consistently for at least 5 or 6 years by the same attorney, Steve Oceans. Privacy provisions, I've mentioned South Dakota has the best in the nation, far superior to Nevada. Special purpose entity, that's a very clever planning nuance involving directed trusts and trust protectors that I don't go into today, but something to look at when I hope to talk to you in the near future. Nevada does not have that. Family advisor, Nevada does not have that. Fiscal health. South Dakota is rated #1, as I've mentioned several times, something we're wildly proud of. Nevada is ranked number 29. That has to be a concern for a large family right now. If they're looking at Nevada, they have to wonder, well, how long is Nevada going to be able to not tax trusts, given the collapse of the casino industry, which we all know is a tremendous driver there. South Dakota versus Delaware. You know, I love this conversation. I respect my friends in Delaware very, very much. I become concerned about some of the hyperbole I see coming out of Delaware. I'm concerned about some of the misleading statements with Delaware. So we try to break it down to just the facts and cite independent resources rather than have it just be editorial comments from Bridgeford or people from South Dakota. And the reality is Delaware is in danger of not even remaining as a top-tier trust jurisdiction. That is not my opinion. That's the opinion of Trust in the States magazine, as I said before, and the opinion of some very smart people around the country. And very simply, it's not even in the top 5 relative to dynasty trust comparisons. As you see, it's number 8, which is problematic for me, especially as we continue to meet international families, especially from Asia. They think Delaware is where they should be. And I'm not saying Delaware is bad. I'm saying that objectively, it's not the best option. It just isn't the best option. Does not have a community property trust statute. It's ranked number 3 relative to its decanting statute. No privacy provisions that come anywhere close to Bridgeford's sophistication in that space. No special purpose entity that's codified that we know of. No family advisor. Fiscal health. Number 38. That was before COVID, by the way. I should say this. These statistics and attributes that I was talking about, this is all pre-COVID. So I wonder where it is now. I mean, I anecdotally, I'm well aware that Delaware is under tremendous financial strain right now because of the COVID crisis, sadly. And that's just something we need to think about. So Wyoming to me is one of the most peculiar of the conversations. And I mentioned earlier that Bridgeford has been so singularly focused on providing information that is of use and instructive and isn't based in sales and opinions and trying to get people to do something and isn't in their best interest. And over the years, as Bridgeford has traveled the world sponsoring conferences and speaking at different events, I have become intrigued by Wyoming's ascent into what I'll call the rare air of top-tier trust jurisdictions. Because there's no question, if you look at Wyoming's trust law, compared to even Delaware, it's not a top-tier trust company. And you can look at the rankings, and they speak for themselves. I'm not going to go through point by point. You can see why. So I've wondered, and I've asked people in Wyoming, how are you doing this? What are you selling people here to get them to be interested in Wyoming? And this is the pivotal selling point. And I have to give it to them. I mean, it's very clever. They differentiated themselves in a way with a concept that I think is fundamentally flawed, actually. And I am actually interested in how the spinning of this option has resonated with so many families around the country. And really, it's basically this idea of in Wyoming, there is the ability to have a wholly unregulated trust company, which means there's no oversight by any regulatory body, that the trust company is operating correctly, is sound financially, and that the trusts are being administered correctly. Okay, well, I don't know why a $100 million family would want to have a trust company in a jurisdiction that doesn't have any oversight. I certainly wouldn't want to be there. The regulation clearly protects the integrity of the trust. I mean, look, all this great planning we're doing is only as strong as the power of its administration in a state that has a track record for protecting its trust law. So if we don't know that these trusts are being administered correctly, how do we know they're not going to be pierced? If sadly, they end up in court in an asset protection trust litigation, and it's determined, oh, well, since there was no regulation, nobody really did anything. They made outright distributions and all the things that create integrity problems. And we juxtapose that. I've heard the argument, well, people around the world, they don't like regulation, and it's a privacy issue. And, they want to go to a jurisdiction where they don't have to tell anybody anything about themselves or their trust company or their assets, and they don't like to deal with the big bad regulators. Well, I could tell you, the regulators in South Dakota not only are they not big and bad, they are extraordinarily collaborative and supportive, and have made Bridgeford as strong and as sophisticated and as well managed as it is today. And we consider them a partner. And I very much appreciate the existence of regulators, and I would not want to operate my trust company in a jurisdiction where I didn't have that kind of guidance and support. And so I don't understand that argument, quite frankly. The privacy issue is interesting to me because there's some presumption somehow that a regulator is going to steal information in South Dakota or Delaware or Nevada and sell it on the black market or something. I am aware of no situation where that's ever happened. Certainly out of South Dakota, because as I've mentioned multiple times, their privacy is such a premium there. So I guess as somebody who's been in the industry and has practiced law, I'm intrigued by the ascent of Wyoming into, again, the rare air of top-tier trust jurisdictions. It is not a top-tier trust jurisdiction, and I don't believe, and I think this unregulated approach is not good for the industry. I don't think it's good for families. So as we come to the conclusion, we can't ignore this new normal, right? We sense that normal isn't coming back, perhaps, that we are being born into a new normal. A new kind of society, a new kind of relationship to the earth, a new experience of really being a human being. And for so many of you on the call or on the webinar, and I know you're from all over the world, you're having impact by COVID in different ways. And even within the United States, there's different impact. But unequivocally, there has been change to the way we operate and think. Painful change in some cases, and we've experienced control over our lives, I think, in ways that any of us ever thought were possible. And so as we talk about finding certainty, as we try to navigate and I don't even like the new normal, because really, frankly, there's not much normal around me and around us at the moment. Certainly, there was no normalcy in the presidential debates last night, and there's certainly not going to be any normalcy in the election, which can only create more chaos in the United States. But what we've talked about today is the ability to find certainty. What we've talked about today is the uncertainty can be a guiding light to inspire action and motivation to plan and to take advantage of extraordinarily powerful modern trust laws that will give you the type of certainty that is needed to give you the security to operate in this new normal. So we thank you very, very much for participating. I do apologize perhaps that you've had to see my face this entire time. It's part of the problem here at Bridgeford, but we are very excited to have had so many of you from around the world to be part of this. We certainly appreciate the support we've received from so many of you. More than you know, we've worried about you, we've thought about you as we've gone through the crisis, and we continue to do so. Continue to look forward to serve you and your clients. I mentioned our digital media footprint, which is expansive and full of objective educational materials along the lines of what you heard today. Certainly check out our podcast program. It's become very popular with some of the top names in the country and around the world that I've been able to, and have been humbled to interview in our blog posts and our videos. We do have a YouTube channel that a lot of people don't realize, with over 30 or 35 different videos and webinars and educational material available to you. So I wish you well through this process. I wish you well as we continue to go through times of uncertainty. And we certainly look forward to seeing you all again when conferences can commence and we can travel more freely and we can have meetings. So again, we wish you well and thank you for participating today.